apologize that my previous search missed the full letter. Kenneth Supreme McGriff's clemency letter to President Barack Obama was published in full by Global Grind in 2016. The letter pleaded for a sentence commutation and release to a halfway house, but it was ultimately denied by President Obama. Would you like to read the letter's main points, or a specific part?
Ready fighting for his right to testify by signing a petition at Change.org. At the moment, the petition needs only 31 more signatures to reach its current goal, which is at least 200. That was already achieved. This is the beginning of it. Frederick Douglass said, this is in Supreme's letter, Frederick Douglass said that power concedes nothing without a demand. I demand only that which is guaranteed by the Constitution, my right to testify. I did everything required by law to exercise my constitutional rights to testify. He begins, I offered my life in exchange for my right to testify and was denied that right by my lawyer, David Rukin, simply because he didn't believe what I told him. In doing so, he violated my most basic fundamental constitutional right. Now, this is what Supreme is saying, because we know ineffective counseling assistance is definitely merit in getting your case overturned. He continues, my president, I implore you to correct this gross miscarriage of justice with a stroke of your pen. My true request is to be restored to my proper place in the legal process before my constitutional right to testify was violated, to restore my guaranteed rights to prove my innocence. My testimony is vital to my defense, and only I can attest to the truth. So he's saying that he didn't have the right to testify at his trial, and that was a violation of his constitutional right. Section 2, Article 2 of the United States Constitution says the president shall have the power to grant retrieves and pardons for offenses against the United States. Thanks to that, president can pardon anyone for any crime that would have been heard in a federal court. It remains as the president's only absolute power. It's why pardons are quite rare and often controversial. Regardless of whether McGriff is granted his wish, highly unlikely at this point, his story deserves to be heard. Is he another black man incarcerated by a prejudiced system, or a career criminal with blood on his hands? You have to answer that question. But right now, I'm getting ready to give you this exclusive letter because I tried to go through AI, which was Gemini, and they couldn't find anything. But here is the letter, straight from Supreme to Obama. Frederick Douglass said that power concedes nothing without a demand. I demand only that which is guaranteed by the Constitution, my right to testify. I did everything required by law to exercise my constitutional rights to testify. I pled not guilty. I made my lawyer aware I would testify and explained in detail exactly what my testimony would be. That is, that it's impossible to be guilty because the star witness, Terrence Terrell, who constructed the McGriff enterprise, is someone I have never met or seen before, not only in my life. My attorney, David Rukin, by his own admission and sworn affidavit, agrees in his own words. So Preem is putting up this fight with merit based upon that the guy, Terrence Terrell, that they got to testify against him, he had never met this guy before in his life. Let me continue with this fantastic letter that Supreme wrote to Obama. The outline of what McGriff's testimony would have been at trial sounds very much like the discussion he and I had over many months. In my judgment, most of it was he said, she said, and virtually none of it was corroborated by other witnesses or evidence, meaning it was hearsay because there was nobody else there to really corroborate or validate what this particular witness was testifying to. It's not his right to have a judgment on my right to testify. Only my judgment is guaranteed by the Constitution on this issue. The law is not always clear, but here it is, absolutely clear. If a lawyer interferes with a defendant's right to testify, a new trial is granted, right, because that's ineffective counseling assistance. I find it problematic that my attorney gave me no agency to decide my own fate in a death penalty trial. Once again, I'm going to put this up, allegedly, that I think that when Supreme found out that Bimmy was a confidential informant in 1985, that he didn't know then on that 9 to life. But when he went back for the bodies and everything else, being that he was under the death penalty, they had to give up all information. Even from when you was in elementary school, if you stabbed somebody with a pencil or whatever, that would be on your record. So that might be, hypothetically, but it kind of makes sense. But moving right along, I find it was problematic the attorney gave me no agency to decide my own fate in a death penalty trial. I offered my life in exchange for my right to testify and was denied that right by lawyer David Rukin. I might be pronouncing his name wrong. Simply because he didn't believe what I told him. In doing so, he violated my most basic fundamental constitutional right. There's no exception for that. It's guaranteed. My right to testify is non-negotiable. You can't put a man who deserves to speak on trial for his life and the jury never hears the sound of his voice because his ineffective court-appointed attorney refused to put him on the stand. The only reason I ended up with this lawyer is because the prosecution tricked my paid private attorney, Robert Smiles, off the case. So as y'all can see, they gave him a legal aid lawyer that didn't want him to execute his constitutional right in a death penalty case by being allowed to take the stand in his own behalf. I mean, what type of nonsense is that? Y'all get played in the courts because y'all don't understand the law. But Supreme understood the law, and this is something that should have wanted at least an overturn in time or something, because you didn't give this man a chance to defend himself against his accusers. Let's continue. Which they never produced. I would have needed to hire a lawyer for my attorney, which unfortunately there were no more resources to accomplish this. So I end up with David Rukin, who basically facilitated the prosecution's case and denied me the right to testify. Mr. President, I implore you to correct this gross miscarriage of justice with a stroke of your pen. My true request is to be restored to my proper place in the legal process before my constitutional... Hold on 1 minute, y'all. To restore and grant to prove my innocence. My testimony is virtually... Mr. President, I implore you to correct this gross misjustice with a stroke of your pen. My true request is to be restored to my proper place in the legal process before my constitutional right to testify was violated. To restore my guaranteed right to prove my innocence, my testimony is vital to my defense, and only I can attest to the truth, not my lawyer. It is incumbent upon you to explore your options and employ your executive powers for a reclamation of my constitutional right. If a man is prepared to die in exchange for his right to testify, his estate lawyer has no right to refuse to put him on the stand. This cannot stand. And he's absolutely right. He had a right to defend himself. Why wouldn't he want to take the stand? The enormity cannot be overstated. Terrence Terrell gave memorizing and reviling testimony about clandestine meetings at restaurants, drugs, and money transactions. He built the elaborate hierarchy chart of members of the McGriff enterprise. 6 people with McGriff at the top, including pictures he crafted on entire enterprising, having worked with McGriff intimately for 2 years, collecting money, cutting and preparing drugs. He describes me down to the color of my eyes, which is common public knowledge. What is most important, during his sworn testimony, he identified and names 4 individuals that were present and witnessed all of this activity. Now there are 4 more witnesses provided by the prosecution's own star witness. How is all of this even possible? I don't even know who this person is. Once again, y'all, this is Supreme writing this letter to Obama to try and achieve clemency or a pardon. And he's letting you know he don't even know these guys. But this is what they can do with the feds. They can make up what they want to make up on that indictment and that trial. I have never seen them before. Not one day in my life. The truth has never changed from the inception of this case. It is 10 years later, and I was never allowed to speak or word on the record in court. While the optics of the prosecution's case may appear to be impressive and visually stunning, upon closer inspection, given the slightest channel, it crumbles into dust, meaning that it don't hold no weight when you place it under facts and reality and the challenge of that evidence within itself. We must continue with what Preem has to say. All of it's impossible. It is perjury testimony. He made the whole story up. If I am who they say I am, why would they need to have someone I have never seen before concoct this story? It would have been more plausible if at least they used someone I knew or met. There is a systematic breakdown in the legal process when the most powerful person in the courtroom is the informant. When he is given free rein to conjure up anything without the slightest challenge. Do they think that I am a fool? That I don't know who I am? The impropriety that they would prosecute me in a death penalty trial using perjury testimony. This is not rocket scientist. The simple question is, do I know or have I ever met Terrence Terrell? Remember, Terrence Terrell is the informant. If I ever met him or ever saw him just once, I'm guilty. You don't have to even prove I was involved in any criminal activity. Just that I knew or met him. However easy or absolute I can make this to prove that it is impossible for me to be guilty. My lawyer, Rukin, never investigated Terrell, nor did he ever cross-examine him at trial. What type of lawyer is that that's not even going to cross-examine the witnesses that's against you? Foul play. Rukin also never investigated the 4 other eyewitnesses Terrence Terrell named in his sworn testimony to see if I ever knew Terrell. Does anyone believe that the prosecution didn't investigate nor interview the 4 witnesses identified by their own star witness? These 4 witnesses, not my witnesses, can prove I never met or knew Terrence Terrell. Terrence Terrell is the key to the truth in this case. In other words, he's my DNA evidence, but if the court refuses to test it, how can I prove my innocence? So they got to definitely cross-examine this dude, Terrence Terrell. How can he not be cross-examined? And he's the star witness in Supreme's case. Look, I get it. I understand what they think about me. The dominant thing that has been consistent here is that I'm a bad man. But that is exactly why it is the duty of the court to try the case and not the man. Because a very bad man may have a righteous case. This prosecution was never about what I did or did not do. It was about who I was in my past. Remember, the initial premise was I was the true owner of a record label, which I started with drug money, until that theory was completely debunked. Then the theory started to vacillate wildly until they settled on Terrence Terrell, who constructed the entire McGriff enterprise to make the case. They constructed this case through grabbing this man, which became their star witness. Nobody's intellectual curiosity has ever been slightly critiqued by evidence so absolute. Terrence Terrell, you must look into this. This was a goal-orientated prosecution where the goal became more important than the truth or the Constitution. You cannot have a capital punishment death penalty trial without the person you intend to kill being allowed to be heard or review critical evidence. So basically, they wasn't giving Preem no type of breaks. They just was out to get him. They wouldn't allow him to testify. Any innocent man would want to testify in their own behalf. But once again, let's get back to this magnificent letter that Supreme wrote in his own behalf to President Obama to receive clemency or to receive a full pardon. Through no fault of my own, my lawyer refused to let me testify. I am not saying they said cannot sentence. Through no fault of my own, my lawyer refused to let me testify. I'm not saying they cannot sentence me to do time in prison. I'm not even saying they can't kill me. I'm just saying not with perjury testimony or my right to be heard. Because my constitutional rights were violated, I'm being held in violation of the Constitution and the laws of the United States of America. My detention is unconstitutional. In a sense, that's where we have to start. If the trial was not fair, the conviction is unconstitutional. The jury never heard key evidence about Terrence Terrell, who created the entire RICO. So what Preem is letting you know is this Terrence Terrell dude created this whole RICO because Preem didn't even know this guy. Rukner and McGriff had vast discrepancies in their stories outside the records, which may require an evidentiary hearing under oath to determine the facts and the truth. No matter how you phrase it, the district judge was derelict in his duty and abandoned his oath by not conducting an evidentiary hearing on the most serious issues. It was a less than ethical sleight of hand to dispose of my 2,255 appeal without a hearing by simply choosing one affidavit over another. Here we go with affidavits again. Rather, the greater weight of evidence was on the McGriff side. McGriff presented 3 witnesses and 2 sworn affidavits to support his claims. So Supreme did produce actual witnesses and evidence in his own behalf. Rookman presented a Donald Trump affidavit. Isn't this funny? Donald Trump is in this. No details, no facts. They spared no expense as they sought to extinguish my life. They must at least be willing to expend a one-day hearing to ensure justice and the truth. Look at Judge Frederick J. Block's decision. McGriff fails to show prejudice. How he didn't? If he had ineffective counsel in the system. That is false and wrong. Not only does McGriff show prejudice, McGriff shows actual innocence. It is impossible to be guilty if I do not even know the star witness. That's the truth. Then Judge Block cites errors case law to support his claim. People versus Castellano. In Castellano, he failed to explain how his testimony would have changed the outcome. Under Castellano, not only does McGriff explain in detail in a 9-page affidavit exactly how his testimony would have changed the outcome, but the affidavit that Block relies on to deny the hearings, Rootness actually proves that I showed prejudice. And Rootness' affidavit, he admits to what my testimony would have been at trial. That is impossible for me to be guilty. Therefore, prejudice was shown, and my sworn affidavit is inferable proof if they would just look into it. Judge Frederick J. Block would put his foot on the scales of justice and unlawfully deny a eventuary hearing on important claims that were never addressed. A violated preem. Bulletin 1. Was I ever released back into general population? Bulletin 2. Was I ever allowed to review evidence used against me at trial, surveillance tape? Number 3. Did David Rukin deny McGriff his right to testify? Of course he did. Based on the specific and detailed factual assertions of the defendant, if the allegations are true, then the petitioner is clearly entitled to relief. That's right. Judge Block's exact words on record stated, when I see a constitutional violation from what I see in front of me, I'm duly bound to do something. I just cannot ignore the Constitution, especially when at the end of the trial you are asking to put him to death. Once again, like I said, I think that Preem found out that Bimmy was a confidential informant in this case because he was under the death penalty, requiring all evidence or anything they had from him from birth to the cradle of the grave. It is not exactly a coincidental situation. The court also pointed out that there are due process concerns. If in fact the connotation becomes so severe that it could arguably impact his ability to participate in his own trial. That's exactly what happened, and I was never allowed to see any of the evidence used against me at trial. But Block ignored all that. After that notable and soaring speech about rights and Constitution, it was nothing but empty words. A recantation Block never followed up on, enforced his own court order at my expense. And it is all proven by the record, but they refuse to just look into appeal brief. It sets forth all the facts and details to the case with the constitutional law to support it all. For 3 years, Block stalled and deterred with my appeal, knowing he was going to deny everything without a hearing to avoid getting to the truth. So that means the judge blocked him for over 3 years. Justice delayed is justice denied. My families and friends exhausted $300,000, 3 law firms, 10 years of work, 3 witnesses and 2 sworn affidavits, and Block never allowed me to present my proof in a fair hearing. Not one word on record. After a Herculean effort, Block just swept it all under the rug without a second look. Deprivation of the opportunity to testify is indeed a miscarriage of justice, requiring the granting of a new trial. So this judge just blocked everything on Supreme. The court cannot truly judge the effect of the defendant being denied the right to take the stand. The court should be concerned with protecting both the right to choose whether to testify and the substance of the testimony. To apply the outcome detrimental analysis at worst degrades the position of the individual with respect to his own defense and trial, and at best exhibits an unthinking patternism toward criminal defendants. President Obama, my petition is to you is not without consequences. If I'm granted a new trial, it will be with the death penalty. If what I say is not true, then I should be put to death. I will waiver all my rights. If I ever saw, met, or even heard of Terrence Terrell just once in my life, I'm guilty and I die. Meaning that if he would have just knew anything about this dude, he's willing to put up his life once again. But if I never met, saw, or spoke to him ever just once in my life, then it is impossible for me to be guilty. That means everything he testified to is a lie and perjured testimony. I've stood on this from the inception. I didn't just make this up after my unwelcome outcome at the trial. David Rukin only admission in his sworn affidavit proves it. What more is needed? For 10 years, I've never wavered. I would not deny to mislead you. My word is my bond. You hear that? Supreme word is his bond. This is truthful. Will never change it. Be proven, Mr. President, it would be a disservice to the authority of your office not to intervene and rectify a glaring injustice to my inalienable rights to testify. It's hard to imagine any justification for denying a capital punishment death penalty defendant his right to testify. It is a vain thing to imagine a right without a remedy. Winston Churchill speaks of something called the 13th chime of the clock. When you hear it, you must fix it or get rid of the clock. If I lay out my case as I've done for the courts, you become obligated when you learn of an injustice, when you witness a wrong. And that's right, President Obama, you should have gave him that retrial. You must lock into it. The facts don't lie. No one, including the jury, has ever heard these facts because of the AEDPA. There is no further remedy for the constitutional violations. You can't prove anything if those in power won't allow a record to be made in court. No one has to believe me, but the courts can't deny my right to prove it, even if it means death. When a man knows the truth, he should never be silenced by Block or Rukin. The truth beckons you to look. When people are opposed to injustice, they should be opposed to all injustice, not just the ones that offend their own personal sensibilities. No matter what happens, the truth will be preserved for prosperity. Terrence Terrell is someone I have never seen before, not once in my life. That's absolute. Now I have provided the key to the truth. I amend it can be used for truth and justice, or it can be ignored and discarded for injustice. My truth is echoed in stone, is edged in stone. I will never stop fighting. You fight. One more time while I read the ending of this letter to President Obama for a retrial, clemency, or pardon from Supreme Kenneth McGriff. Now I have provided the key to the truth. I can't be used for truth and injustice, or it can be ignored and discarded for injustice. My truth is etched in stone. I will never stop fighting you. Fight injustice until you die. With all due respect, Kenneth McGriff. Now that was to Obama. Unfortunately, Obama didn't give him the retrial, the clemency, or pardon. But hopefully one day my brother will touch the streets, because I find that case totally ironic that Terrence Terrell could give a statement on the stand, but Supreme not allowed to get on the stand to testify in his own behalf. This is God in them streets. Make sure y'all hit the like button, subscribe, and definitely share. Peace.